Good afternoon. I've got the last slot of the day. There is a bit of time pressure, of course, because we are slightly overrunning. I hope you can stay awake just a little bit longer and that you haven't all sugar crashed on the starburst. I certainly managed to eat all of mine before John had even finished his introduction. A lot of you seem to be a bit more restrained. I can see lots of full packets around. Anyway, today I'm going to give you an update on sentencing, try to find some interesting cases to talk to you about, spot any trends that there might be. So the key point is proportionality of fines to financial circumstances of defendants. So I've got a few recent cases on fatalities and non-fatalities. And now I'm going to talk about the case of Cayley, where the Court of Appeal has given some guidance on the discount that should be applicable for guilty pleas at different stages of proceedings. Unfortunately, I'm not going to be talking about a huge fine for the architect who designed Lakanal House. I'm sure he deserves one, but he probably got a prize instead. So a bit of background. The Criminal Justice Act 2003, section 164, says, of course, that the amount of any fine should reflect the seriousness of the offence. It also, of course, says that the court must take into account the circumstances of the case, including the financial circumstances of the defendant. The guidelines at paragraph 12 remind us that there is no direct correlation between the size of a company or an individual, in terms of wealth, of course, and culpability. Therefore, of course, being a small company does not mitigate, and being a large one does not aggravate the offence. Paragraph 16 reminds us that the court must look not just at profit, but also at turnover and assets. And certainly there's an interesting case that I'll be taking you to, which is the case of M&M Contracting, down at the bottom there, which deals more closely with that particular point. Now I'm going to talk to you about these cases which all involve fatalities. There are 5 there. They're all slightly different. There are some big fines, big companies involved, and some smaller ones, and we'll be able to pick out some kind of trend, I think, towards big companies getting big fines, but smaller companies perhaps getting fines that potentially hurt them more because of their overall size compared with the fine. So Merlin Attractions, the first case. Now, Merlin Attractions owns and operates theme parks and other visitor attractions within Europe. It's second only to Disney, so it's large. They have many, many different sites, and one in particular is Warwick Castle. Now, there were 2 bridges entering into Warwick Castle, 10th century castle, and these are the originals. One happens to have, or had, a 15-inch parapet wall, so a very low parapet wall. And the circumstances of this case are that a 72-year-old man managed to trip over that parapet wall and fall 13 feet into a dry moat. It was obscured with vegetation, but that didn't stop him, didn't break his fall, such that he did die from his injuries. Now, the prosecution said millions of people, literally, have visited Warwick Castle and been exposed to this obvious risk, and the fact that there's been no previous accident was simply a matter of luck. Now, of course, the defence said, well, the fact that so many people had walked over this without any problem means that there was no material or foreseeable risk, and that had been illustrated by the lack of accidents. Now, no concerns had been raised whatsoever by the visiting environmental health officer, nor indeed by the head of building control from the local council. However, the court said, well, there's no proper risk assessment for the bridge. You should have erected side barriers to reduce what was an obvious and significant risk to all visitors, but particularly to vulnerable visitors such as children and elderly people. They said, the court said that the company had failed to act following an independent report back in 2003, which had actually raised the issue of whether barriers were required. Now, in this case, no financial information was provided to the court, and that actually did anger the judge quite significantly in this case. But of course, he concluded that that meant that he could give them any fine that he could think of effectively, because it meant that they could pay it. Now, the fine, in fact, was £350,000, and the costs on top of that were £145,000. So you can see significant sums. So, of course, there was an appeal, and the Court of Appeal said that, in fact, the risk was foreseeable and obvious, and had existed over a long period of time. Millions of people had been exposed to that risk. And they did stress that the court's primary role was not to achieve consistency, but to impose a painful punishment, tailored both to the offence and the offender, and was designed to have an impact. So the fine was upheld, and they did say that although it was at the top end of the scale, it was still within the appropriate range. Now, the next case of D. Roche Limited is quite a different sort of company. D. Roche ran a small care home for the elderly. There was a particular resident who was in her 80s who was identified as being at high risk of falling because she'd actually fallen twice before whilst she was living there. And accordingly, a care plan was drawn up, and that stipulated that a wheelchair must be used whenever she was being moved around outdoors because she was at risk of falling. Now, unfortunately, a junior care worker took her out with just a Zimmer frame, and the old lady fell and sustained fatal injuries. Now, this junior care worker was completely unaware of the two previous falls and was not aware of the need for a wheelchair. So it's gone off the bottom of the page there, but hopefully you can read it on your handouts. There was no proper system, the judge found, for ensuring that care workers were aware of the content of care plans, despite the vulnerable nature of the residents. Now, looking at the financial circumstances of Roche, it had a turnover of about £1 million, and the previous year had had a profit of £46,000, but a loss was expected in that current year of around £30,000. The fine was £150,000, reduced to £100,000 on account of the early guilty plea. So we can see there, compared with the previous case of Merlin Attractions, where it was a substantial fine, the £350,000 fine, but of course their turnover and their profit was in the multiple millions. You can see here that, of course, if a loss of £30,000 is expected in that current year, how long it's going to take to pay off a fine like that. It's inevitably going to hurt a smaller company much, much more. Indeed, there was an appeal, and the Court of Appeal did find that the fine was manifestly excessive because there were plenty of mitigating features in the case, such as a high ratio of staff to residents, no previous convictions, and a good approach to health and safety generally. So the fine was reduced from £100,000 down to £70,000, but we can still see that that would hurt this small company a lot. And yes, it was extended from 12 months to 3 years for payment of that, but that would still be extremely difficult to pay. The next case is Allied Domecq. Now, Allied Domecq is a large wine and spirits company. It's a major wholesaler in this field. And it had a warehouse down in Dover that happened to have a leaky roof and needed the gutters clearing out. They contracted with someone called Mr. Parker, who was trading as Ovenden Engineering, to undertake those works. Now, unfortunately, one of Mr. Parker's workers fell through a fragile skylight to the concrete floor 6 metres below and died later in hospital. Now, the roof was fragile, and it was apparent that there was no safety equipment in place whatsoever. No crawling boards, no scaffolding boards, no harnesses, no nets. And that had been the case despite the fact that there had been monthly works taking place at this particular warehouse. Now, what the court said was that as the owner of the warehouse, Allied Domecq had responsibility to ensure contractors planned their works, carried it out safely, and that proper control measures were in place. And accordingly, Allied Domecq was fined £400,000, reduced to £267,000 for an early guilty plea. Costs were less significant, at almost £11,000. Indeed, Mr. Parker was also fined, but that was a far smaller sum of £40,000, reduced to 27 for the early guilty plea, and costs of £4,000. The next case is the case of Watkin Jones. Now, Watkin Jones is a large construction company, and they subcontracted works to another company, which was then subcontracted further without them knowing to another company. And unfortunately, there was an accident on site, but it was apparent that Watkin Jones had retained management responsibility, even though it didn't know that there had been that further subcontraction of the workforce. Now, there happened to be a void that was covered with plywood with no crash deck beneath it, and unfortunately, a 21-year-old roofer fell through that plywood and sustained severe head injuries. It took him 2 years to die from those, but they were very significant. Now, a jury found that Watkin Jones had, in fact, been directly involved in creating the circumstances that led to the fatal accident, in that they had known about the hole and had not put a crash deck in below it, and that accordingly it was an accident waiting to happen. The financial circumstances of Watkin Jones was that they had a substantial turnover of in excess of £100 million and pre-tax profits in excess of £13 million. It was a massive fine of £450,000 with £98,000 of costs. On appeal, the Court of Appeal submitted that Watkin Jones, or rather John Cooper on behalf of Watkin Jones, submitted that the fine was wholly disproportionate as there had been subcontracting and the company that did that work had played a significant role in the accident. Further, that Watkin Jones had cooperated fully and remedied the defect immediately. However, the fine was upheld, and the Court of Appeal did say that there were cases where the main contractor was so far removed from the offence that it could not be liable, but that was not the case here. Watkin Jones had been directly involved in creating the circumstances that led to the death, and they had to accept significant responsibility. So the next case was the one that I mentioned earlier of Contracting Limited. Now, this is where we see that the court will look quite significantly into what the financial circumstances are. It was a small company undertaking building and joinery works. There was one director only, and the accident circumstances were that there were fibre boards which were stacked vertically, and father and son were working together, and they needed to get a board out from the middle of that vertical stack. So the father was holding them on one side, leaning back against him, whilst the son was trying to pull one out of the middle. And unfortunately, the father couldn't sustain the weight of it, fell backwards, all the boards fell back on him, and he was crushed to death. He actually died there and then, which shows you how serious those crushing injuries were. Now, the investigation showed that there was no supervision whatsoever. Indeed, there were no instructions about the boards whatsoever. There was no written health and safety regime at all. Ideally, the boards should have been stacked horizontally, or indeed vertically, but in a purpose-built rack. Now, M&M Contracting Limited argued that they had limited means due to the fact there had been a recent repayment of a loan to the sole director of £26,000. So they said, well, because we've paid back this loan, we don't have enough money to pay a significant fine. And the judge said he would have felt constrained to only fine the company £10,000 or thereabouts, but for the recent ability of the company to repay that loan of £26,000. He accepted that in strict law, this £26,000 was owed to the director, the sole director, you remember, but he referred to the money as having been salted out of the company and said a robust assessment was called for. And as a result, the fine he gave was £26,000 with costs of £9,000. Now, this was appealed, and M&M Contracting argued that the repayment of the loan was lawful and a proper transaction, and that the judge was not justified in taking that loan repayment into account. The Court of Appeal said the fine was not excessive, and that the net assets of a company are not necessarily determinative of its ability to pay. The level of fine is not to be dictated exclusively by a defendant's balance sheet. And this is the key point here. The reading of accounts is not simply a look at profit and costs. They said it was wrong for a company to be able to take advantage of reducing cash balances in this way. And they further reinforced that by saying that what the judge did not constitute an infringement of the limited liability principle. So we do have to be careful in looking at profit and loss accounts to actually look further than that and see whether anything has been going on which means that the company would have been in a better position to pay a fine. Now, moving on to a non-fatality case, the case of Palmer and Harvey McLean Limited. Now, this company is a national food distribution company. It's quite a large one. They provided unsuitable footwear to an employee who was working in a walk-in freezer store. Now, as a consequence of being exposed to cold for quite some period of time, the worker developed a debilitating long-term nerve damage condition to his feet, which spread up his limbs, which was likely to be permanent. The company admitted a failure to provide suitable PPE for a period of 18 months, despite repeated complaints from their employee who had been saying, my feet are cold, these boots aren't right, and all they'd done was given him a different pair, which didn't fit him properly either. The court found that there'd been a lack of risk assessment and that they'd have a dismissive attitude to the employee's complaints. Now, once again, no financial information was provided by this large company, nor any indication of the director's earnings, nothing. And the fine here was £75,000. On appeal, the Court of Appeal said the fine needed to be large enough to bring home to both the management and shareholders the importance of ensuring a safe working environment, and that here there had been a prolonged breach and serious long-term consequences to the employee, and that a substantial fine was warranted. However, they did say that the fine in this case was too high, and it was reduced down to £50,000. The next case of a non-fatality is the case of Tufnell's Parcels Express Limited. Now, this again is a nationwide company. It's a parcel delivery service. They have 25 odd depots to which bulk deliveries of parcels are made. Unloading took place at night time and involved 45-foot trailers being reversed into bays. We can see how this could result in a nasty accident. But what happened was that on a night shift, a porter was directing a trailer when the trailer rolled back and trapped his head against a wall, causing him serious head injury. Now, the Health and Safety Executive investigated and revealed that, in fact, the defective shunter vehicle that was moving backwards, the driver's vision was restricted when he was reversing. Further, the yard was inadequately lit, loading bays weren't marked, and there was a lack of health and safety training for employees. And apparently a risk assessment 8 months earlier had failed to identify a safe system of work. And we have to question how they didn't identify some of those issues, not least the key matters of lighting a yard in the dark when vehicles are reversing and marking out the loading bays. And indeed, the court found that the whole approach to health and safety was markedly deficient. There were widespread failures, and that they had been in place since 2007. To add to the difficulty in defending a case like this, Tufnells had in fact pleaded guilty to a similar offence in 2009. Now, the turnover of this company was approximately 100 million, with an operating profit of 7.7 million. And the fine given here was £150,000. Now, of course, this is a substantial company, and £150,000, when you're talking about profits at that level, one might think is pretty light compared with what smaller companies are getting. And that's the picture that I suggest we can see building from these cases, that big companies, yes, are getting bigger fines, but they're much easier for them to pay relative to their actual profit and turnover compared with smaller companies. And indeed, in a case such as this, of course, it was not a fatality, but it could so easily have been, with serious head injuries in this case. A fatality, of course, took place in Watkin Jones, and in that case, of course, the profit was just over 13 million, and the fine was £450,000. So in this case, it was pure luck, effectively, that the man had not died. And the difference in fine is obviously very significant for a pretty similar sized firm. Anyway, on appeal, Tufnell submitted that the judge had placed excessive weight on non-causative failures and had also given inadequate credit for their guilty plea. The Court of Appeal said, however, that it was not manifestly excessive. It was a large, profitable company, a wholesale failure to address obvious risks, and a long-standing, non-isolated failure, and so the non-causative failures were still relevant. Now I'm going to trespass on your patience for a little while longer before drinks and canapes. I realise people need to leave, and I do understand that. It's simply the case of Cayley. That is a case where the Court of Appeal has given some guidance on the kind of credit that should be given when defendants plead guilty. So the Sentencing Guideline Council's guideline says that there should be a 1/3 discount for defendants who indicate their plea of guilty at the first available opportunity. Now, it's made clear in Cayley that this does not mean at a police interview. It was specifically said that such admissions at interview are assessed along with aggravating and mitigating factors in determining the sentence before adjustment for the plea of guilty. So previously, that had been an unclear area. There had been some confusion between the first reasonable opportunity for a defendant to indicate his guilt and, secondly, the opportunity for his lawyers to assess the strength of the case against him and advise him on it. Now, what the Court of Appeal had said, and remember that this is a pure criminal case rather than a health and safety case, had said that whilst it is perfectly proper for a defendant to require advice from lawyers on the strength of the evidence, a defendant does not normally require it in order to know whether he was guilty or not. A defendant requires advice in order to assess the prospects of conviction or acquittal, which is, of course, different. Now, I'd suggest that that's obviously less relevant in regulatory cases because, of course, if you've burgled a house, of course, you know whether you're guilty or not. But in fact, in regulatory cases, it's quite difficult to know what the position is. Sometimes there isn't one single individual who knows what the company was doing, and indeed, legal advice is generally required to know what the position is. So that particular part of Cayley is not so relevant to regulatory cases. Now, the guideline said the reduction in sentence was appropriate because of various different factors that made it in the interests of the public purse, effectively. It avoids the need for a trial. It also shortens the gap between charge and sentence. It saves considerable costs. And it saves, of course, very importantly, victims and witnesses from the concern about having to give evidence. Now, the guideline is that individual cases call for individual decisions, but of course it's desirable to have a consistent approach between courts. Annex 1 of the guideline says that at a first hearing, if you make a plea of guilty, then the discount should be a third, and if it's at the Crown Court preliminary hearing, it should be 30%. But the practical reality is that the maximum reduction will take place at either of those occasions. A plea of guilty at the PCMH would not ordinarily be significantly different from a plea notified shortly thereafterwards. That's because regardless of the exact procedure in different courts for fixing trial windows or trial dates, this was the stage at which the guidelines contemplated a reduction of about a quarter. Now, the meaning of indication of a plea of guilty includes where a defendant's counsel or a solicitor notifies the court that the defendant would be willing to accept or admit a lesser charge, or indeed invites discussion as to the appropriate charge, and that's provided the position taken is a reasonable one. Now, if a guilty plea is given at the first reasonable opportunity, there is, of course, as I've said before, a presumption of 1/3 reduction. But what the Court of Appeal said is that even if there's a reason not to make that full 1/3 reduction, the reduction should still be in the order of 1/5. Now, that's, of course, because there are still public benefits flowing from a guilty plea at that point in any event. And this is regardless of how overwhelming the evidence is. Indeed, the Court of Appeal reminded judges that they should be wary of concluding that a case was overwhelming when they'd only seen evidence that was not contested. The Court of Appeal also said that whilst it may be tempting for courts to avoid reduction in sentence for guilty pleas where the statutory maximum sentence was low, and that the resulting sentence was therefore felt to be insufficient, the Court of Appeal said, resist this, as the guidelines set out, the sentencer cannot remedy the perceived defects by refusing to apply the appropriate discount. So they must apply these discounts even though they don't think that the end figure is sufficient. Now, Newton hearings, what the Court of Appeal said that if a Newton hearing is necessary because the defendant asserts a false basis of plea or indeed disputes part of the case against him and then his case is rejected, this should be taken into account in determining the level of reduction for guilty plea. And the Court of Appeal said this is common sense, as the reduction in sentence is to recognise the public benefit that flows from the guilty plea. So indeed, it's not necessary or possible to provide rules as to what reduction should survive when you actually go to a Newton hearing. But of course, it depends on all the circumstances of the case. So if the Newton hearing was on quite a narrow issue, then that would be relevant, or indeed whether lay witnesses had to give evidence, and indeed the extra public time and effort involved. And of course, if the Crown could not prove its own version of events at the Newton hearing, there would be no effect on the reduction for the guilty plea, so that would still stand. Now, even if there's a guilty plea in the course of the trial, there is still some residual flexibility to give some credit for that plea. And that's, of course, because there's recognition of there still being a residual public benefit, particularly in long and complex trials. But of course, they did stress that that doesn't mean that in every case there should then be an investigation into what savings have and have not been made. Now, I've rattled through those cases. You do have, of course, our handouts from today. I suggest that those cases that I took you to earlier do provide some trend towards perhaps overly high fines for smaller companies, whilst bigger companies are not getting off lightly because the fines are big, but relative to their turnover and profit, they are doing better overall. And indeed, the case of Cayley simply clarifies a position on guilty pleas, which previously was not entirely apparent. Now, I hope you've thought up some tricky questions, particularly for John Cooper, to make up for him not having to prepare a talk for today. I don't know how much time we've got left for questions, John.
My Thank you, Julie. I think we've actually pretty much overrun. If anyone's got a burning question, please feel that you please ask it. If not, it may be better if we adjourn for a drink and you could put any questions down, either asking us directly or by sending it by email. If anyone's got an urgent question and has to go, feel free to ask it now. Good. That means we can go for a drink. So thank you very much indeed, everybody.